Steve, thank you for agreeing to do this interview about the developments and the history behind 102B7. Let me start by saying I know that you were on the corporate council back in the middle 80s. What were you doing what law firm were you with, and what was your focus at that point?
At that point, I was a partner in Skadden Arps, Slate, Meagher and Flom, which is a New York headquartered office with a substantial Wilmington presence at the time. And my work mostly involved takeovers, one way.
And so the 1980s, you were intimately involved because Skadden was one of the biggest firms around dealing with takeovers in general and takeover litigation in particular.
Yes, that is correct.
Okay. All right. Well, can you tell us how you became involved in considering an amendment to the corporation code that eventually became 102B7?
Well, I was sitting as a member of the Corporation Law Council, and I don't remember whether it was the first year I'd been on the council or not, but it was certainly among the first. And in attending meetings of the council, I recall the issue of the D&O crisis coming up, and it came up in conjunction with probably some general unhappiness about the Supreme Court's recent decision in the Van Gorkum case.
All right. And tell us a little bit more about why this uncertainty or unhappiness was of such concern to directors. Was it because it was hard to figure out, for example, what gross negligence was, something like that?
Well, certainly. And also, it was the first case in which any Delaware court had ever, in circumstances like this, held members of a public board of directors liable for the way they conducted themselves in connection with, in this case, it was a takeover. I mean, the company was sold to one of the Pritzker entities, as I recall. And there was a very long litigation that went back and forth to the Supreme Court a couple of times, which ultimately resulted in a finding of liability. And it was substantial. I don't remember what by today's numbers, it doesn't look like so much, but it was millions, maybe $10 million, something in that order of magnitude.
And do you recall whether there were other cases, not in Delaware, there were also, but in this period of time, suggesting that directors could be liable for lack of care?
I don't so much, no. I imagine it's true, but I don't remember that.
Yeah, I think there were a couple of federal cases that had gone in that direction. All right, well, you became involved, and now we're in the middle of 1985, 1986. What's your first recollection of being specifically focused on 102B7, or what became 102B7?
Well, I have looked at minutes of the meetings of the council during this time frame, and I noticed in doing that at the March 10th meeting, this issue was raised, and the first thing I saw about any contribution I made was a comment at that meeting that I thought the best approach would be a legislative amendment eliminating financial liability on the part of corporate directors for breach of the duty of care. And that was part of a larger discussion about limitations on liability or changes in the indemnification statutes. It didn't gain support of the council in general.
All right. Now, in part, your ideas evolved a little bit, and I think that we're talking March of 1986, of course. After that, I think, did you, in your thinking process, consider the views of such people as the ALI and et cetera?
I did. I remember or recall from reading this that a reference to a project that Louis Loss was in charge of at the time. Louis Loss was a very famous corporate and securities law professor at Harvard Law School, and at this time he was leading the American Law Institute project on trying to come up with a restatement of the law of corporations. And one of the things I understood, it seems from reading the minutes at the time, was that the ALI at least was considering an approach that, among other things, would cap liability. Of course, the problem for a corporate director, as opposed to running your own affairs, let's say, is that you are often called upon to make decisions that have very enormous financial consequences, consequences that can dwarf your own net worth. And even for high net worth people, it's a very, it's a proposition in which you're getting paid at this time $10, $20, $30,000 a year, and you're exposing yourself to potentially tens of millions of dollars of liability. And so it's pretty it's a little hard to understand why you would agree to do it, other than for the obvious reasons of prestige and so forth. And you're certainly, at the time anyway, weren't doing it for the money. So I think it's also clear at the same time, both the federal government through the SEC and the Delaware Supreme Court were pushing for there to be larger proportions of independent directors on corporate boards. So it's one thing for the president and the senior executives of a company, and maybe the family member who controls the company, to sit on the board. All of their interests are at stake. It's something else to get an outsider to come in and expose his or her net worth to liabilities arising out of that activity. And so there's this pressure to get more independence on the board. The idea that you're now going to get more of them on, have what you think is a better board process, and then expose them all to basically unlimited liability was at some tension. So,
Yeah, I seem to have read in one of the articles in preparation for this that there were, in fact, people resigning from corporate boards. Was that your experience as well?
I recall that. Yeah.
And because of this spectrum of potential liability, is the main reason for doing so. Is that?
Yes, and I remember people asking advice whether they should serve on boards, and it was very hard to give someone sort of unbiased advice that it's a good idea.
Mm-hmm. Now, I think you had mentioned it, perhaps.
To make that point, this is in conjunction with this D&O crisis that was going on, right? I mean, if you're fully insured and you're not at bankruptcy risk and you can count on enough insurance, it's one thing. If you can't get the insurance, or if it's very expensive for the corporation to buy the insurance, it's something else.
And this was what was going on in 1984, 1985, et cetera.
It was. I mean, I think for reasons that had nothing to do with the law. I think it was just an insurance market problem at the time.
It affected other professionals as well, like doctors, for example.
Yes,
Okay.
that's my understanding.
Yeah, that's my understanding as
Right.
well. All right, now, so you mentioned that you had a very direct approach to this problem, but I know that later you proposed in April of 1986, in conjunction with other people, that perhaps one way to deal with this problem was a cap on liability. What was your thinking in your April 1986 memo about that issue?
I did, and I frankly had forgotten all about this before I saw it when I was preparing.
I don't want to bring up ugly memories, but
But evidently, my partner Ed Welsh at Skadden and Tom Allingham and I proposed or drafted this proposed Section 146 that would have placed an aggregate cap of $1 million on the liability of directors as a group for breach of the duty of care in any given transaction. As I read the draft today, or when I read it this morning or last week, it seems to have had some real serious problems in the way it was structured. But
well, just as a general idea with a cap, how did that fly, or didn't it?
it was the idea of a cap was discussed at council, and I think I know I've heard Mr. Sparks say, and I don't remember this, and I may not really have been very much privy to it at the time because I didn't do any tort work, and there was no one in my office who did. I mean, we weren't doing malpractice. We weren't doing basically anything other than corporate work. So I don't remember that I was aware at the time, or at least at the beginning of this process, about the fact that there was this tort reform legislation also working its way through the legislature that created a real problem for the Bar Association to be, on the one hand, be supporting a cap for director liability and opposing it for everybody else. So that does seem to be a significant political problem.
Yeah, I would think so. All right. Well, we know that after the proposal started to circulate through various meetings at the council, you had further involvement. What do you recall was the next involvement that you had with respect to a proposed exculpation statute?
Well, I do remember that I guess it was Norman Vesey from, who at the time was at Richard Slayton and Finger, subsequently became Chief Justice, proposed a statute that would amend Section 102B, which I know you've already been through this, and I shouldn't, probably
No,
don't
go
have to
ahead,
repeat it
because
again. I mean, 102B is the provision that tells corporations what they can put in their certificates of incorporation.
Mm-hmm.
And so this proposal was to permit companies to adopt provisions and either amendments to or original provisions that would exculpate directors for, essentially for violation of the duty of care. So it was not too far off the idea I had in a sense that, but instead of legislating it, it would permit companies to choose to put this in their own certificate of incorporation.
And therefore have the stockholders consent to it.
Yes, and then the stockholders, either by being in the original certificate or through an amendment process, the shareholders would have consented to including this in the certificate of incorporation. So it's more, it has perhaps greater legitimacy than just to do it by legislative fiat.
All right, and do you recall any particular debates, such as, for example, do you recall any debate about officers being included in the statute?
I do a little bit. It gets mixed up in my mind with debates about officers being subject to long-arm jurisdiction, which I think was being also reviewed at the same time. I don't remember that being a big issue because we were there to talk about director liability. There hadn't been any recent case law unexpectedly finding directors or officers liable for violating their duty of care. So that wasn't really the issue of the day, so it wasn't addressed.
I noticed in the statute that there is a provision in there that talks about not in good faith. Do you recall a discussion about that? Who proposed that, why it was proposed, and what was said with respect to it?
I do. And it goes back to the fact that this statute is drawn, it could have been drawn to say you can put in your certificate of incorporation a provision that exculpates directors from financial liability for breach of the duty of care.
Just that simple.
Period.
Yeah, okay.
I think that didn't happen because of the sensitivity of appearing to reverse even this indirect way, Van Gorkum. So instead of doing that, it's the other way around. So you can exculpate for everything other than the breach of the duty of care. No, I probably just said that backwards.
Yes.
You can exculpate everything in the world except the whole list of things, which when you put it all together adds up to everything other than the breach of the duty of care, right? So it's a more difficult drafting process, I think, because you had to include the duty of loyalty. You can't exculpate the duty of loyalty. And then you had to include all these statutory provisions like dividends and surplus and things like that. You can't exculpate those because they're in the statute. And then I do remember, to get back to your question, a meeting at Morris Nichols' office, which at the time was over in the IMP building, at which, maybe it was the final meeting to consider this, at which Mr. Rosenthal said that he believed the statute should include, as one of the things you cannot exculpate, was a breach of the duty of any action not taken in good faith.
Okay.
And I remember that discussion because it was a couple reasons. I mean, my view of it was that things that are not in good faith violate the duty of loyalty. And so it was, to me, surplusage. And it didn't need to say that. I thought since it was, to my mind, surplusage, it created some risk of
Ambiguity?
ambiguity and hazard in putting it in the statute because it meant there now was going to be an argument or having to go through some process of deciding what this duty of good faith became. And it was presented in the negative as actions not in good faith. There even became a question of, and this did, because as you know, I later became a member of the Court of Chancery and had a lot of cases dealing with these problems over the years. So there was 97 to 2009.
Yeah, I want to get into that, but first I want to finish up with
All right,
just
back-
talking about that.
Back to that meeting.
Right.
But Mr. Rosenthal was quite insistent that it needed to be in there to gain his support. I think there was a lot of unease among all the other members of the council in the room, but in the end, people agreed to it, to put it in there.
And then, of course, subsequently, the statute was enacted, and you had the fortune or misfortune of having to deal with it as a member of the judiciary.
That's right. I don't have much recollection up to the enactment. I don't really remember the section meeting, and I had nothing to do with the General Assembly.
Well, that's like I said before, well, that was over 30 years ago.
Yeah, I don't remember any of that. I remember Bruce Stargett's objection, and
Right, and you remember
it
that got
causing
resolved.
it causing real consternation in the council, but it got resolved.
All right. I think for me at least, valuable and really interesting perspective is yours as a member of the Court of Chancery, having to deal with that statute. Can you tell us a little bit about how the court dealt with it initially and how that evolved over time? Because I think it's an interesting story.
I'm only going to tell you in generalities because I briefed it and ready to talk about cases. But to my mind, Ed, as much as the statute went down smoothly every other way, when it got into the courts, there were a couple of problems. And the first problem was how this statute would be invoked in a lawsuit procedurally. And I think when it was adopted, it was everyone's expectation that it would cut off at the beginning litigation that only involved issues of care. Litigation that was seeking money damages and not some other form of relief, and only involved issues of care.
I agree with that.
And everyone thought that was going to happen. Right?
But that didn't happen.
And it didn't happen.
All right. What did happen?
What happened was that I believe the Supreme Court held, in a case I can't remember the name of, that this was in the nature of an affirmative defense. And so that means, and not an affirmative defense like an immunity, because that's an affirmative defense, but one that can be raised at the threshold of a litigation. More like an affirmative defense that you had to go through discovery, get to the end, and get sort of ready for trial when it could be presented as a summary judgment motion. And that undermined, for some period of time, undermined the utility of 102B7 as a device to protect against directors and their insurance companies, because this was largely designed to make sure that the insurance people would be in the market. They basically had to pay out. They had to pay a lot of money to get to the point where they could say, wait a minute, this is a 102B7 issue. So generally speaking, that did eventually get resolved, but it took a long time.
And how was it resolved?
The Supreme Court eventually said that you could, if a complaint's filed that only alleges things that fairly read are duty of care issues, and is only seeking money damages, that it can be dismissed at that point.
Now,
The other question, or the other thing that happened was, and to the point of the Joe Rosenthal language, we went through a period of time in the jurisprudence where it was suggested by a number of cases that the fiduciary duty directors owed really was in 3 parts, not 2 parts. It was the triad of duties, and it was loyalty, care, and good faith. And good faith was quite hard to define. You might, not surprisingly, if it isn't just loyalty, what is it? And it became, at least in public statements by members of the court and in some opinions, it became very much like the duty of care. And so it seemed as though it was 102B7 was not fulfilling everything it was supposed to do. That it finally was put to rest, but I don't think that happened until 10 years ago.
The Disney case, you think, put it to rest or not?
I don't remember.
Yeah, all right,
I
fine.
didn't brief this, so.
No, I
I
understand.
remember it finally, we got rid of the triad of duties, and people came back to realize we're just dealing with 2, not 3.
And is it your thinking, as it is mine, that that's basically where we are today?
Yes.
Okay, so
I should add that I think in England, there's really only one duty of fiduciary duty, and it's essentially the duty of loyalty. So,
well, but we don't want to be English, do we? All right.
and they never understood what we were doing with all of this.
That's a way above my pay grade, I can tell you that much. All right, well, that's very helpful. Do you have any other recollections that you'd like to share with us with respect to 10BT7, even not so much the drafting, but even as your role as a vice chancellor? Or do you think
No,
we've covered it?
no, I think we've covered that. Like I said, I didn't brief it, so I'm not going to give you the case citations, but it was both as a vice chancellor, and there was a period of time in the early 2000s when I was teaching this law up at NYU, and I guess I've lectured on it in other places. And it was always an issue that I have been asked to address. In fact, Gil and I have, a couple of years ago, were asked to do something like this at Penn Law, and I was again taking the position we should have just eliminated liability for the duty of care. Saved ourselves a lot of trouble.
Well, it just looks like you've been vindicated, buddy. So, good for you. All right. Thank you so much for participating.
So before you guys